Today is a big day for marriage because the United States Supreme Court issued two decisions that are very important for same-sex couples that want to marry. One decision involves the challenge to the Federal Defense of Marriage Act, which is a federal statute that defines marriage for federal purposes to a contract between one man and one woman. That's the law that was challenged in the Windsor case, which came out of New York. The other decision, called the Perry case, is a challenge to a California state amendment that did much the same thing. In other words, it defined marriage as involving only a man and a woman, but that affected only California state law. And to understand what today's rulings mean for same-sex couples, I think the easiest thing for us to do is to imagine two couples. Imagine a same-sex couple legally married in Massachusetts, which allows gay marriage, and a same-sex couple living in Florida but unable to marry because Florida doesn't allow gay marriage. They're both better off today than they were yesterday. Because if you are a same-sex couple in a state that recognizes gay marriage, the federal government now has to treat you the same way they treat straight married people. So the couple in Massachusetts, from our example, that was legally married in Massachusetts and is still in Massachusetts, they're now going to enjoy all of the rights for federal purposes that straight couples enjoy everywhere. And they're also going to enjoy all of the rights that straight couples enjoy under state law. Does that mean that that Massachusetts gay couple has the same rights as a straight couple? Unfortunately, even after today, the answer is no. Because when that Massachusetts couple leaves Massachusetts and goes into a state like Florida that doesn't recognize gay marriage, Florida isn't going to have to recognize their marriage. Does that mean that the federal government can treat that couple differently? In other words, if you are that same-sex Massachusetts couple and you move to Florida, does that mean that you lose the federal rights that were created today? I don't think so. But I think what we will be seeing is a statement on the part of the federal government in which they say, because we know that people move around and are sometimes married in one state that recognizes marriage and then move to a state that doesn't, we're clarifying that in situations like that, we're going to treat everyone like they're legally married. That's what I expect to happen. So I think it's just a question of time. So the Massachusetts couple that's legally married today is better off because of DOMA. How about that Florida couple? Well, unfortunately, that Florida couple isn't legally married under Florida law, so they don't qualify for the federal rights that were created today. What do they have to do? Well, they have to get married in a state that recognizes gay marriage. What options do they have? Well, they can move. They can move to a state that recognizes gay marriage, get married there, and then they'll be treated, for federal purposes, the same as straight people. One thing that I think might happen, and I haven't seen it happen yet, but I wouldn't be surprised if, for example, a state, a very progressive state, gets into the business of helping couples like this. Because maybe, I could imagine a state, maybe Massachusetts, maybe New York, saying, you know, we know there are all these gay couples out there that they don't want to live in our state. They want to live in their own state that doesn't recognize gay marriage, but they want to have federal rights. How can we help them? Well, we can let them come into our state, get married legally, and then go back to their home state. And that way, they still won't be married for state law purposes, but they will be married for federal law purposes. What the court held today was that when Congress defined marriage as involving a contract between a man and a woman only, that Congress was overreaching its power. It was doing something that it did not have the power to do. And the case today gave two reasons for why Congress was overstepping itself. First, they said, marriage is a state law question, and it's not the federal government's business to make policies about what the states should be doing. Leave that to the states. But the court also made another argument, and this was the formal frame for striking down DOMA. What they said was that Congress was not treating gay people the same as straight people. It was not affording them the equal protection of its laws. And that's a very different kind of argument, because what that argument is saying, that argument does the exact opposite thing that the states' rights argument does. The first argument says, you know what? This is the business of the states. The federal government has no business intervening here. The equal protection argument says quite the contrary. It says, you know, when the government does act, it's going to be subject to the Constitution, and that's going to limit its power. So potentially, you could. That's an internal. I think that's an internal inconsistency in the Windsor opinion. But what the court signaled is that they may, in the future, strike down state laws that discriminate against gay marriage. They didn't do that today, but they may in the future. So that, and I think what that means is we're going to have a lot more litigation on this question.